Morning, everybody, and welcome to this morning's In-House in Focus webinar. Today we're going to be looking at insolvency and what you should do if a business that you're dealing with becomes insolvent or looks like it's approaching that stage. As the government's COVID support schemes wind up, it is a sad reality, I'm afraid, that we will see some businesses failing. So the aim of today is for our insolvency specialists, Neil Smyth and Morgan Bowen, to take you through what you can expect if a business you're dealing with goes into insolvency, and to give you some hints and tips as to how you might make recoveries from that business. I may be a bit biased, but for insolvency specialists, I think I must say that Neil and Morgan are very lovely people and very approachable. So please do pop any questions that you've got in the Q&A box at the bottom of the screen. When you ask a question, they don't appear to other attendees. So please don't feel constrained if you have a question that you are worried may be a little bit sensitive. Those questions are not public to all participants. The aim of today is that you will have a 40 to 45 minute sort of formal presentation, and that allows us plenty of time to deal with questions that you've got. As with all our In-House in Focus webinars, this webinar is going to be recorded, and links to the recording and also the presentation slides will come through to you in the next few days. Finally, at the end of this morning's session, there'll be an opportunity for you to give us feedback. And your feedback is really valuable to us because it allows us to shape future sessions and make sure that we are dealing with topics of particular interest and relevance to you. So please do at the end take a moment to give us some feedback. Neil's also going to be running some polls in a moment. So without wasting any more time, let me hand over to Neil and Morgan.
Thanks, Jane. And thanks for that build-up. I will try and be as lovely and as approachable as I can this morning. But as Jane says, please let us have your questions. We will leave ample time at the end for questions. And if we do overrun, that's not a problem from our side if you have any other questions that you want dealing with. So as Jane said, I'm Neil Smyth. I head up our national restructuring team at Mills Reeve. And it is a sad reality of the economy at the moment that if you're not already, you will be dealing, unfortunately, with businesses that are getting into financial difficulty. So the idea behind today is to really split this presentation down into two parts. Morgan is going to be talking about what you do if a counterparty goes into an insolvency process, and then I'm going to follow on from that, talking a bit more about if it happened next time round, or if it happens to you now, how do you protect against that counterparty insolvency to try and improve your recovery. Before I pass over to Morgan, though, to talk on the reactive side, we have a poll split into two questions, which hopefully should be coming up on your screen now. Firstly, have you had to deal with any contracting party going into an insolvency process? And secondly, if so, has your organisation taken any steps beforehand to improve recovery? Obviously, the answers are anonymous, but if you could vote now, we'll have a look and see what the experience of the audience is. We'll just give it a bit of time so everyone has a chance to vote. Okay, well, hopefully that's given everyone enough time just to go yes or no. And if we could have the results up. Okay, so the majority of the audience has unfortunately had experience of another party going into insolvency process, but a minority of the organisation has actually done anything to improve recovery, which is okay. What I anticipated. And obviously the idea behind today is hopefully to give you some options that you might be able to take away and have a think about as to how your organisation might be best prepared to actually make a recovery. And as I will talk about later, that's subject to cost benefit analysis, etc. But there are different ways of achieving that, both practically and legally. Thank you very much for doing that poll. I will now pass over to Morgan, who will talk a bit more about what happens, what you should do if your counterparty goes into an insolvency process.
Thanks, guys. Hi. So I'm just going to talk, as Neil was saying there, just in a more reactive way, and then Neil's going to discuss the proactive, the ways you can change things in the future to improve your position. I'm going to talk initially about the different corporate insolvency processes in England. There are quite a number. It's quite a complicated regime. I'm then going to talk about the waterfall in administration and liquidation. This is basically the order in which creditors and other interested parties get paid out of the administration realizations. I'm then going to talk a bit about the legal effect of administration and then about asserting one's rights in an administration. This is on the basis the administration is the regime you're most likely to come across in practice. So if we could move to the next slide. So starting first with the moratorium procedure. This is a new procedure introduced by the Corporate Insolvency and Governance Act 2020. The SIGA was passed at some speed by the government in the wake of the pandemic. The Act introduces two new insolvency procedures, one of which is the moratorium. The moratorium was introduced to address a perceived defect in English corporate insolvency regimes, in that there is no insolvency procedure in which the management can remain in control of the company, save for schemes of arrangement and for company voluntary arrangements, or CVAs, which are complicated and require the agreement of the creditors or a large part of them. The new moratorium procedure enables a company to avail itself of a moratorium, preventing secured and unsecured creditor enforcement during the course of the procedure, while the directors remain in control of the company. So moving on to schemes of arrangement. A scheme is a mechanism under the Companies Act 2006 by which a company can agree a compromise or arrangement with its members or creditors or any class of them. It can be utilized by both solvent and insolvent companies at the instigation of the company itself, with the directors remaining in control throughout. The people affected by the scheme are divided into classes, and to be approved, the scheme must receive the approval of each affected class, and a class must be confined to those people whose rights are not so dissimilar as to make it impossible for them to consult together with a view to their common interest. So effectively, you take different sets of creditors, split them into classes based on their common interest. Each class votes separately, and provided you get 75% by value in each class voting in favor, and the court also approves the scheme, then the scheme binds dissenting creditors in each class. Next up is restructuring plans. The restructuring plan is the second new procedure introduced by the SIGA. This procedure closely resembles the existing scheme of arrangement procedure. In particular, it can be used as a debtor in possession tool, with the directors remaining in control of the company. Secondly, the people proposed to be affected by the procedure are broken down into classes and vote by their separate classes. The main difference from the already existing scheme procedure is that the court may, in certain circumstances, still sanction a scheme under the new restructuring plan, even if one or more classes has rejected the scheme. Typically, schemes and restructuring plans are seen with the bigger companies, and one is less likely to come across them in practice with smaller companies. A procedure that one is likely to come across in a smaller company context is the company voluntary arrangement, or CVA. The CVA is a rescue procedure commenced by the directors of the company by making a proposal, which is then voted on by the shareholders and the creditors. Typically, CVAs are proposed further down the decline curve from schemes and restructuring plans, but further up the decline curve from administration and liquidation. It is possible for a CVA to deal with unsecured creditors in different ways. However, the CVA cannot affect the rights of secured creditors, and nor affect the priority of payment of preferential creditors without their consent. Approval by the creditors requires at least 75% by value of the company's unsecured creditors voting in favour. And all unsecured creditors have a vote, including those whose debt is not being compromised under the CVA. So contrast this with a scheme under which only affected creditors vote, and then in schemes they voted by, and also restructuring plans, they vote in classes of creditors separated by classes with not dissimilar rights. The CVA is a much blunter instrument. In recent years, CVAs have been widely used by retailers seeking to compromise landlord liabilities, usually on terms that other trade creditors are paid in full. Next up, we have receivership. Receivership is a form of security enforcement available to fixed charge creditors where their security has become enforceable. And for this purpose, one needs to distinguish between fixed charges and floating charges. Fixed charge security prevents a chargeor from disposing of the charged assets without the consent of the secured creditor. By contrast, a floating charge offers more flexibility, permitting the chargeor to deal with the assets in the ordinary course of its business, including disposing of the charged assets without the chargee's consent. There is a disadvantage for floating charges, however, which I will come to in a moment, which is that they appear further down in the waterfall of payments. The appointment of a receiver ordinarily does not require the involvement of the court. It's a contractual appointment started by demand under the loan arrangement. Moving on to administration, which is the procedure one is likely to come across most regularly. Administration is a process typically used further down the decline curve from schemes and CVAs, but up from liquidations. I will come on to it in a little more detail in a moment, as it's the procedure one is most likely to come across in practice, as I was saying. And then finally, among all these various different corporate insolvency regimes we have, you have liquidation. Now, liquidation is the process by which a company is wound up, it's sometimes called winding up, prior to its dissolution under the control of a liquidator. There are three types of liquidation. You have members' voluntary liquidation. This is an out-of-court process instigated by the directors where the company is solvent. Then you have creditors' voluntary liquidation. This is an out-of-court process instigated by the directors where the company is insolvent. And then finally, you have compulsory liquidation. This is a court process usually instigated by an unsecured creditor presenting a winding up petition against the company at court. In all three types of liquidation, trading will ordinarily cease and the liquidator will seek to realize the company's assets to make a distribution to creditors. So if we can move on to the next slide. So what do we have here? So we have here the waterfall of realizations in an administration or liquidation. So this is basically the order in which people get paid out of the assets of the company administration or liquidation. So first up, we have the costs and expenses in realizing the fixed charge assets of the company. So if there are fixed charge assets, there may be costs of realization of the receiver or of the chargee if it goes into possession itself in realizing the fixed charge assets. Those come out as the first priority. After that, we have the liabilities of the fixed charge creditor itself. So the loan debt under any facility agreement, for example, under any loan that it is the fixed charge creditor has lent to the debtor, and including any interest on their debts as well. Then after that, we have the administrator/liquidator fees and expenses. So these are the administrator's own remuneration for the work it's doing in the administration or in the liquidation, and then also its expenses. So, for example, legal fees and other fees. These can be quite considerable and can often eat into, well, not necessarily the legal expenses, but the administrators and liquidators' remuneration can be quite considerable and often eat into the realizations. After that, we have preferential creditors. So these are principally made up of certain claims of the debtor's employees. And then from 1st December 2020, HMRC has become a preferential creditor again for certain tax liabilities. Then after that, we have the prescribed part. This is an amount that needs to be set aside out of the floating charge assets to settle claims of unsecured creditors, which is currently subject to a maximum of £800,000. Then after that, we have the floating charge creditors. So you can see the disadvantage I was talking about earlier for floating charge creditors as against a fixed charge creditor. Fixed charge creditor comes out with a first priority. The floating charge creditor comes out much lower down in the order of priorities. In particular, preferential creditors are paid in priority. The prescribed part is effectively paid in priority. And also the administrator and liquidator fees and expenses come out in priority. But the advantage, of course, for a floating charge security is that it allows much more flexibility to the chargeor to dispose of the assets in the ordinary course of their business. So then we come on to unsecured creditors, and then interest on the unsecured creditor claims, and then finally shareholders. So we can see that the unsecured creditors are near the very bottom of this waterfall. And this is the critical point, which is that the return to unsecured creditors out of administrations and out of liquidations is very poor. Sometimes it can often be nil, or just a few p in the pound on their claims. And this is why it is so important to give real consideration to how one can improve one's position. And this is what Neil will be coming on to. So if we can move to the next slide. So I'm just going to talk a little bit about the legal effect of an administration. An administration is the procedure that you're likely to come across most often in practice, a liquidation as well, but in a liquidation there's likely to be even less realizations for the unsecured creditors. An administration is designed to be a short-lived procedure to ring fence the company from creditor action, while the administrator implements proposals to rescue the company as a going concern or achieve a better realization for the company's assets than in a winding up, or to realize the company's assets for the benefit of its preferential and secured creditors. The first purpose of a rescue of the company as a going concern is in practice rarely achieved, but the company's business can often be saved by means of a sale of the business and assets of the company as a going concern. Upon a company entering administration, the director's powers effectively cease and the company comes under the control of the administrator. An administrator can be appointed to a company either by the out-of-court route of filing notices at court or by application to court for a court order. The out-of-court route is much more common and is used by the company or the holder of what is known as a qualifying floating charge. And a qualifying floating charge is a floating charge that extends over the whole or substantially the whole of the company's property. For an appointment by the company itself, the company has to be unable or likely to become unable to pay its debts. For an appointment by the QFC, the qualifying floating charge holder, the security must have become enforceable. Another term you'll come across is pre-pack. A pre-pack is an administration through which the business and assets are sold by the administrator immediately on the company's entry into administration. This helps preserve value as it minimizes the erosion of value that occurs by reason of the insolvency being known to the world. Because once the insolvency of a company gets known to the world, immediately that erodes value. It is, however, a highly controversial mechanism in that such sales occur usually without the administrator having fully tested the market, as obviously testing the market would notify the world and erode value. And it occurs without creditor approval, with the administrator essentially seeking the consent of the creditors only after the deal is done and the horse is bolted. And the government is considering introducing mechanisms to protect creditors in the pre-pack scenario. Well, they haven't yet been introduced. An administrator has the benefit of a wide moratorium that prevents enforcement action being taken against the company, not only by unsecured creditors, but also by secured creditors, unless the consent of the administrators or the court is obtained. In this way, administration differs from compulsory liquidation. In compulsory liquidation, the moratorium does not prevent enforcement action by secured creditors. It prevents enforcement action only by unsecured creditors. But most importantly, the administration moratorium does not alter a counterparty's substantive rights. It merely means that the enforcement of those rights is suspended for the duration of the administration. Now, the moratorium can be lifted with the consent of the administrator or the court. Permission will normally be granted for the lifting of the moratorium where the counterparty is seeking to assert proprietary rights, which will not impede the purpose of the administration. In any other scenario, the court conducts a balance and convenience exercise, balancing the convenience for the creditor seeking the lifting of the moratorium against the interests of the company administration. There is also the effect of CGAR on supplier termination rights, which applies in an administration and other insolvency procedures. But Neil will be coming on to that shortly. So if we can move on to the next slide. So moving on to the assertion of rights in an administration, we first of all, the first issue is whether the creditor has security. If the creditor has security and it's a fixed charge security, the administrator needs the consent of the charge holder, or will have to go to court to sell the asset. However, there's no ability during an administration for a fixed charge creditor to appoint a fixed charge receiver. As regards floating charge assets, no consent is needed for the sale, but release of the security is usually required in the ordinary course by purchasers before purchasing floating charge assets. In the case of retention of title, now this is something that Neil is going to move on to discuss, which is a mechanism by which unsecured creditors can protect themselves. The administration moratorium prevents creditors from enforcing their ROT rights during the administration, although the creditor can obviously apply to lift the moratorium in the usual way. But importantly, again, the moratorium has only a suspensory effect, suspending your ROT rights during the course of the administration. It doesn't prevent, it doesn't cause those ROT rights to fall away altogether. Normally in an ROT situation, you will want to contact the administrator forthwith to inform them of your ROT rights. And this is to ensure that the administrator is aware of the title rights and to reduce the risk of accidental disposal of the assets. And finally, there we have the unsecured creditor. And as mentioned previously, the lot of the unsecured creditor in an insolvency procedure is not a happy one. And if the unsecured creditor has no security and has no ROT, the creditor can make a claim in the administration. And no particular format is required for that claim. They can simply write to the administrator informing them of their claim and the amount that they're claiming. And the administrator will potentially write back. If they're happy that the claim is proved, they may need no further evidence. But the administrator may write back if they consider that the claim hasn't been proved. And you may then get into an argument over whether the claim is a proper claim. One needs to be careful, of course, because given that a lot of the unsecured credit is a very poor one, if one doesn't want to be expending lots of costs in back and forth with the administrator seeking to approve a claim, where the return to creditors is poor. Now, I've just got a query here, so I'll very quickly answer. Someone's querying the use of the word chargee and charge all. So charge all means the debtor, which is giving the security, and chargee means the secured creditor who is receiving the security. So that's the difference in those things. Charge all being the person entering into the charge, giving the charge to the secured creditor. So that is my slide done. My slide's done. I'm going to move on to Neil now to move on from the reactive to the proactive.
Thanks, Morgan. Yes, so for the remainder of the session, and we'll have some time for questions, and I see that we've got a lot of questions, so we'll, as I say, we can hang around and answer them, but we'll try and get as many done by the 11:15 deadline. So I'm going to look briefly again at one of the slides that Morgan's talks about regarding recovery and why this is also important about being proactive. Some practical suggestions without involving the lawyers and potentially saving some costs, which I'm sure you will be delighted to hear about. And then 3 areas where you probably will need to involve the lawyers, but it may well be subject to a cost-benefit analysis that I talked about at the beginning, worth looking at to try and improve your chances of recovery through retention of title, which Morgan has touched on, but then also some provisions around protecting yourself where you retain possession, and also through the documentation that you use. So if we could have the next slide. So I'm not going to go through this again. Morgan's been through it. The point is, if you do nothing, then you will be an unsecured creditor. And as Morgan said, if you're an unsecured creditor, then you are pretty much at the bottom of the pile. In an insolvent process, you would not expect shareholders to recover any money at all. Unsecured creditors sit basically above the shareholders. On a survey that was done about 5 years ago regarding prepackaged administrations, the estimated return to unsecured creditors was between 1 and 3 pence in the pound. The general return to unsecured creditors is pretty much zero. The only way that they normally recover anything is through the prescribed part, which comes out before the floating charge realizations that Morgan has already touched on. An additional whammy to be looking out for is the fact that HMRC has become, from the 1st of December last year, a preferential creditor. And that is a double whammy because A, that puts the chances of recovery for unsecured creditors at less than they were. So you can probably scrap your 1 to 3 pence in the pound and put it lower than that, if you can get lower than that. And B, you'll also be aware that various organisations, particularly those in financial distress, are not paying various taxes, which will now form preferential creditors. So HMRC is A preferential creditor, but B, for larger and larger amounts due to COVID. And therefore, at the moment, unsecured creditors' recoveries in an insolvency process are looking less and less likely. So that is why it is also important, if we could move on to the next slide. What can you do about it? Well, looking firstly at the practical, adjusting contractual terms is a vague suggestion, but it'll obviously depend on the nature of your business. But there may be things that you can do with your customers, suppliers, counterparties that will actually improve your chances of recovery purely from a practical basis, in line with whatever business you are in. More specifically, the obvious way to try and improve recovery is to tighten your payment terms. So if you are due to be paid within 60 days, could that be 30 days? If it's 30 days, could it be 15 days? With a view to then linking into the next suggestion. And again, these are all practical suggestions, not involving the lawyers, not involving the cost, is just as an organization getting much tighter on credit control. So that may be in conjunction with adjusting and tightening up your payment terms. It may be just making sure that as an organization, you are sticking to those payment terms. If it's 30 days, then, are you getting paid within that 30 days? And if you're not, then what are you doing about it? And are you keeping the credit control as tight as you can? That is difficult at the moment in light of the temporary COVID provisions that are in place, because the ability to actually collect debts, particularly through the insolvency courts by way of service of statutory demand and presentation of winding up petitions, is effectively on hold. And if you have to go down the litigation route, the courts are very busy and are not moving quickly, as you may well have experienced in your own organisation. So in a way, that is easier said than done. But at this time, we would obviously be recommending that you keep your credit control as tight as you can in relation to your organizations. Lastly, there is credit insurance. So, you can take out credit insurance to try and protect against non-payment of debts. I see credit insurance more in the context of where a company has gone into an insolvency process acting for the insolvency practitioners. My understanding, not that I'm an insurance expert, is often it can be expensive and difficult to obtain. And so, again, it's going to be a cost-benefit analysis as to whether that is right for you, but it is clearly something that you should be thinking about if you don't have it in place already. And if you do have it in place already, is there anything else on that slide around the practical that you can use to actually reduce down your premiums and try and make it a more cost-effective way of protecting yourself? So those are just some examples of the practical. If we go on to the next slide, looking more then at what you can do on the legal side. This is probably the most common provision that those that supply will be looking to include in their standard terms to try and improve their position. So you'll all know that if you supply goods on terms, title passes on delivery, and therefore if you don't get paid and your customer goes into an insolvency process, you are an unsecured creditor. And I won't bang on again about the consequences of that from a perspective of recovery. But if you retain title against the standard position under the sale of goods legislation, then you actually own the goods until you have been paid. What that means in an insolvency situation, as Morgan has touched on, is that those goods are not available to the administrator or the liquidator to sell. And if you have valid retention of title, they will have to be returned. Now, practically, as Morgan's touched on, if you do have ROT, even though there is a moratorium preventing you from enforcing your rights, you need to go and identify your goods as quickly as you can. And I'll come back to that as a minute. But from the legal point of view, it is a question of ensuring that you have some kind of retention of title provisions included in your standard terms, ideally to cover the total debt you are owed rather than on an individual basis per invoice. In order for it to work, as you may know, I've put these steps really as to practical, because if you can't identify what you've supplied under ROT terms, then even if you've got the most amazingly drafted terms whatsoever, it's going to make absolutely no difference, because if you can't identify the goods, you're not going to have an ROT claim. And the administrator may or may not be on notice of a retention of title claims, but as soon as that business goes into an insolvency process, you need to be identifying the administrator as quickly as possible that you've got ROT to give yourself the best chance of actually having an ROT claim through identification. If you can identify some goods that are still held by the company, covered by your ROT claim, then it's a question of establishing that your ROT terms have actually been incorporated into the terms and the contract between you, either express agreement or battle of the forms, etc. Many of the things that I'm sure you've been involved in around contractual terms. And if it is validly incorporated, does it actually work as a retention title clause? Now, that is a whole presentation in itself, but that's just a very high level view of retention of title. Next slide, please. So there are, and again, these solutions, if they are solutions, will depend on the nature of your business and what you're doing. If you are supplying, ROT might be for you. If you are receiving, it won't be. But there are various things you can also look at to protect your position through possession. So if you are holding money on behalf of other parties, do you want to try and set up some kind of trust fund to protect that money, to the extent that if the other party goes into an insolvency process, that money is held on trust for you and does not go into the general insolvency estate and be lost, leaving you as an unsecured creditor. Escrow arrangements, possibly for cash, but most commonly, if you are involved in technology businesses, for software codes, etc. How are those going to be held? If you have licensing arrangements, if you are using software, if that party goes into an insolvency process, how are you going to resolve those difficulties going forward? How are you going to be able to get hold of the software code quickly to ensure that you can continue your business, notwithstanding the insolvency of your counterparty? And again, that is a whole presentation in itself, one that I did a couple of years ago as part of this program for those who might have been on that. But with escrow, what you're trying to achieve really is that you can demonstrate some kind of title to whatever asset is held in escrow, because if the escrow doesn't work and the title passes to the company in administration, then you're going to be left as an unsecured creditor, which, as we talked about, is where you don't want to be. Liens, again, if you're supplying in conjunction with title or as an alternative to title, you can, if you are holding goods on behalf of others, as opposed to supplying, then you may be able to assert a lien over those goods, which will give you the right to retain those goods until you've been paid. Those will need to be in conjunction with something in your terms allowing you to actually sell or take possession of the goods and sell them to make a recovery. But if you are holding goods on behalf of others, that might be something that you want to think about in an effort to try and protect yourself above and beyond the normal position as an unsecured creditor. The next slide. So last slide from me, but looking a bit more at the documentation. Morgan has touched on the new SEGA legislation that came into force last summer. One of the standard provisions that you would have in your documentation would be termination. So if another party goes into an insolvency process, you are able to terminate that agreement. Now, you should be aware, to the extent you're not already, that the new legislation prevents termination based on insolvency without the consent of the relevant insolvency process, or much less likely consent of the court order, which is obviously going to be an expensive process. Now, the vast majority of the time, you are probably going to get the consent of the administrators. But if you are providing a key supply to the company in administration, and that company particularly wants to continue to trade with that supply or keep that supply in place to sell on, then the administrators may well not consent to termination, and that may not be a route that you would have, even though it is in your standard documentation or your contractual terms. So just be aware of that. Having said that, if the administrator needs you for continued trade or sale, then hopefully at the very least you will get paid post administration for that trade, and you may be able to negotiate a better deal with the ultimate purchaser if you are a key supplier to the business. Set-off is particularly important in respect of administration's contractual set-off. There is statutory set-off in liquidations, and in limited situations there is statutory set-off in administrations, but that only occurs where the administrators make a distribution to creditors, which is a pretty rare occurrence. So it is very key in your contractual documentation that you have contractual set-off, because if you don't, what you may find, and we've seen this particularly over the last 12 months or so, is that you have to pay a debt that you owe to a company in administration, and then you have an unsecured claim which is probably worth nothing in relation to the amount that you are owed, rather than being able to set off one against the other. So you should, at the very least, have contractual set-off in your provisions, assuming that it works as part of the broader relationship that you have. Morgan has talked about security and how that will elevate your chances of recovery. And so that's something to think about if it's right for your business and the trading relationship, putting security in place. And so you can actually enforce that and get your money back that way. Or alternatively, you look for guarantees from third parties to ensure that if the principal obligor goes into an insolvency process, you have other parties that you can call on to actually get your money back. So that's a very quick whistle-stop tour through various different provisions, both practical and legal, but hopefully that gives you some ideas as to what you might be able to use to try and protect your position and increase your recovery. Jane, I'll pass back to you. I think we've got loads of questions and not much time, so I will let you decide who goes first, and we're quite happy to answer questions for as long as you want us to answer them, but appreciate that we said 11:15 as a finish, so if people have to fall away, that's obviously completely understandable.
Yes, Neil, what I'll try and do is group them together because I can see some themes coming out of them. So there are a couple that are related to the domestic construction sector. One is a really interesting question around a contractor ordinarily being responsible for a defects liability period of, say, 6 years, and what happens if that contractor becomes insolvent. Does effectively your sort of assurances through the defect liability period fall away? So that's one question there.
Yep.
And related to that is the question about a contractor becoming insolvent. What are the implications for somebody involved in perhaps managing the contract? So, for example, a contract administrator, perhaps an architect, somebody of that nature. So perhaps you could deal with those two to start with, Neil.
Yeah, I mean, the construction sector is particularly difficult as regards insolvency because there are various different parties involved who all have contractual nexuses with each other. And where one party goes into an insolvency process, that has a knock-on effect for various different parts of that contractual nexus. In relation to warranties, if you have a warranty, if you have warranty protection with an entity that goes into an insolvency process, then the warranty doesn't necessarily fall away, but the liability under that warranty will be unsecured and therefore subject to everything that we talked about this morning and the difficulties of recovery. If someone buys the business, there is a chance that they may be prepared to step into the shoes and novate the contract and take on the warranty, but generally they will be looking to negotiate their way out of that and only provide you warranty protection for the contract going forward rather than for the works that have previously been done, and that's really just going to be a commercial issue. In relation to the second question as to how the failure of one part of the contractual nexus in the construction industry will affect others will obviously depend on the contracts. But often what you are looking to do is to leapfrog that entity who has gone into an insolvency process. You may want to establish direct contractual links with someone else within that chain, or if someone is going to buy the business, get them to step into the shoes of the party that has gone into an insolvency process. But again, that's most probably going to be by way of negotiation. It's very hard to document for that, and you can't force a new party to enter into the same contractual terms. So it's going to come down to a question of commercial leverage in the negotiations.
Okay, thank you. The next theme that I've spotted is around retention of title. So we've got a couple of questions on that. The first one being around tracing issues and whether there are any changes that the audience ought to be aware of with respect to tracing. I think this must be tracing goods that are subject to an ROT through the supply chain. And a similar question, Neil and Morgan, is around retention of title. What do you do if the goods that are subject to the ROT can't be located? So the company that's insolvent doesn't know where they are, and the administrator doesn't know where they are either. So can you comment on those 2 points?
Yeah, I think the rules haven't greatly changed. The law hasn't greatly changed recently around identification. I think the thrust of the question is probably where the product that you supply gets incorporated into another product. And the basic rule there is that unless you can remove your product without damaging the overall product, then you will have lost, your product would have lost its identity for retention of title purposes, and you won't have a claim in relation to that product. In relation to the whereabouts of goods, I mean, as I say, this is the importance of identification. If the goods have left the company's possession and they are somewhere else, then as a starting position, your ability to assert a retention of title claim is probably gone. You may have the ability to assert that retention of title claim in the hands of a third party, but generally, unless that third party is a party to your contract, if they are receiving your parts in good faith without notice of your retention title claim, then that's going to destroy your rights, unfortunately.
Yeah, the only other thing,
and presumably, Neil,
you sometimes see these proceeds of sale ROT clauses as well, where you don't just take a retention of title in the goods that you've supplied, but you take a retention of title into the proceeds of sale of those goods. And yeah, that can work in practice, but usually it doesn't, to be honest. And one of the problems there is that once the goods have been sold and the proceeds have been realized, they then get mixed in with the other cash assets of the business, and it can be very, very difficult to engage in a tracing exercise then. As Neil says, in reality, it's the best way to ensure you protect yourself through RT is to as best possible, try to get the goods separated from other goods and to mark them very clearly so that they're very clearly identifiable as your goods. Once they're sold on, once they're mixed in with other goods, probably the ability to trace at that point is in reality lost.
And presumably, Neil and Morgan, an administrator really has no interest in helping you to assert your ROT.
Well,
no. I mean, I think as an officer of the court, they can't, bury goods or make them disappear. But the obligation to identify particularly and prove your claim is very much on you.
I mean, if there was a sort of willful default, they could be liable for conversion of the goods, of course. But it might be very, very difficult in practice to prove that. But I mean, I think the key aspect absolutely is to get in contact with the administrator as early as possible. And as Neil was saying, is to make it very clear as possible that a mechanism of identifying the goods and separating them from the company's own goods.
Okay. The next theme I've identified is around, I suppose, mitigation and protection. So one question is, can you get insurance, which I'm to protect against counterparty insolvency? Which my guess is the only thing you might get is trade credit insurance, but
yeah, so credit insurance, as I've talked about, if you can get it and it's cost effective to do, because I understand it's quite expensive.
Another question that has come up, which relates to a business owing money to an insolvent counterparty, and can you just ignore their requests for payment? So can you just decide, well, actually we're not paying you because you're insolvent? So have you got a view on that?
Well, legally no, because ultimately it's an asset of the company in an insolvency process, and the job of the administrator liquidator is to realize that asset. So they will come after you, and they have the power and ability to pursue proceedings. As I said earlier, this is why set off is so important, because if you are owed money, what you don't want is the sickening feeling of having to pay money into the black hole of the administration and then getting 1p of that money back with all of the other creditors, because you're rank equally or more likely getting nothing. So don't ignore it, because you may well be on the other end of legal proceedings commenced by the administrator. But one of your defenses to that claim is going to be set off, and I think that is, if you are going to do nothing else out following this presentation, I would recommend that you look at your set off provisions generally across your contracts and try and ensure as much as possible that you have that ability, because that is going to be your best chance of not necessarily improving your recovery, but reducing your additional loss is probably the way of looking at it.
It's interesting that you raised set off, because that has come up as a question. The question being, if set off's activated in the event of insolvency, would that be treated as a preference?
No, because you can only have a preference before the company goes into an insolvency process.
Right.
Afterwards, it can't be a preference. It's just an invaluable right to try and reduce down your loss effectively.
Yeah. Okay. Another question around protections is vesting certificates and parent company guarantees. Do you think that those offer any additional protections?
I would recommend you get them if you can. I mean, they're only as good as the covenant strength of the party providing them. So, if you're dealing with an SPV shelf company and you're not happy with their covenant strength, and you want, the parent, if the parent is also of similar low covenant strength, you're not necessarily improving your position. One thing to be aware of with guarantees is obviously that you want them to be a guarantee of performance, but also an indemnity in relation to the debt, such that the guarantor is the principal obligor along with the counterparty. And if there are any changes to terms, etc., that the guarantor is also aware of those terms and signs up to them, so they can't argue after the event that the debt is increased or the terms have changed, and that's not what they signed to guarantee, and therefore that could potentially invalidate the guarantee. So there's various minefields that you need to watch out for, but in principle, taking a guarantee from a party that has a better covenant strength is obviously something you should do if it's available to be taken.
Yeah, I would only add on the financial contagion point, really, which is obviously if you've got a group of companies, as Neil's saying, you've got your debtor. If you get a parent company guarantee, that there could be a risk of contagion. So if the debtor becomes insolvent, there's a good chance that the parent company can also become insolvent. But nonetheless, there's still value in getting a guarantee, because you have claims against, even if both go insolvent, you have claims against both insolvent entities, and can get a payment as an unsecured creditor out of both of them. So there is still some value in getting a parent company guarantee, even if the guarantor goes insolvent as a result of financial contagion in addition to the debtor.
Thank you. I'm very conscious of time, so I'll just try and pick up a couple more that hopefully we can answer quickly. How easy is it to use the insolvency process in the UK in an English law contract with a foreign entity?
Yes,
that might be a question around termination, triggering termination. I'm not quite sure, but
well, it's a whole different presentation around the joyous word Brexit, because for some shocking reason, insolvency processes and the harmony of insolvency processes across the EU was not at the top of Boris Johnson's list when he did his deal just before Christmas. And unfortunately, the EC regulations that we had in place up until the 31st of December that did harmonise insolvency processes between the EU countries is no longer in place. And therefore, we are in a bit of a void at the moment as to exactly how that interaction will work. But if you are entering into a contract with a EU incorporated entity, or any foreign incorporated entity for that matter, you should assume that the insolvency process and the insolvency law that will apply to that entity will be the law of the company that they're incorporated in. So if you're dealing with a French entity and they go into an insolvency process in France, assume that French law is going to apply to your contract. It might not, and there are various different rules around that. But I think it would be sensible in those circumstances to think about local advice, if it's cost effective to do so, to see whether all of these amazing claims that all of these amazing terms that you have in your standard conditions would actually work in a French, Spanish, German insolvency, or whether they would not be worth the paper they're written on. So that's something that I think you've got to bear in mind.
And just going back to SEGA and Neil Morgan, this is something that we've talked about together a lot. In light of SEGA, can you suspend services rather than terminate?
In short, you can't, no. So you're required to continue supplying. Basically, the way it works is, if you've got a clause that says you can terminate by reason of the counterparty's insolvency, that clause is just nullified altogether, whether it's suspense or termination. But if you can terminate for other reasons, for example, termination not to do with insolvency, but to do with non-payment of ongoing supplies, that termination right isn't prevented by SEGA. So you should be able to ensure that at least your ongoing supplies to the insolvent debtor during the course of the insolvency procedure are being paid, because otherwise you would have a right to terminate in those circumstances.
Yeah, as Morgan said, you've got this class of administration expenses which comes pretty high up the waterfall, and if you are required to supply post administration to a company to allow it to continue to trade, you should be paid as an administration expense. That is not a guarantee that you will get paid in full, but as you might remember from the slides, the administration expenses come out before the administrator's costs, and therefore on the basis that the administrator is only going to take the administration if they're going to get paid, they will work out what the costs of trading will be, and they will work out that they will make sufficient money out of that trading to repay those people who are incurring debts during the period of trading, to ensure that they can actually take their costs. So you pretty much, legally you're not guaranteed, but practically you're pretty much guaranteed that you will get paid in relation to your continued trading from the date of administration, but you'll be unsecured for your supply up to the date of administration and will have difficulty terminating over that. But as Morgan says, if you're not paid as administration expense post administration, then you will be able to terminate. There's no reason why you should continue to supply an insolvent company and not get paid.
Thank you. One final question. Any tips on getting an administrator to cooperate and help you? And I think the context of this is, for example, a supply of equipment where you might also need technical manuals and so on that haven't been supplied.
Yeah, I mean, it's the administrator is going to have 1,001 things to do and 1,001 creditors to deal with, and it's all about how you try and elevate yourself up that list. And there's various ways of doing that depending, you know, what you're trying to achieve and how your supply or, you know, equipment fits into the structure of the business. For example, if what you're trying to get back is integral to the business, albeit as Morgan's talked about, there's a moratorium preventing you from actually taking that back, you could, in theory, apply to court for permission to do it. So one way to get the administrator's attention is, at the very least, to be saber rattling and threatening such a court application to try and get their attention and to try and reach a commercially acceptable solution to the problem that you've got. But there's no hard and fast rule. I mean, unfortunately, if you are an unsecured creditor who is not integral to the business, then your ability to get the attention of the administration in those circumstances is going to be very limited. Hence, I guess, back to the theme of all of this, which is that if you can improve your position, not only are you improving your recovery position, but you're also improving your negotiating position with the administration, and that may well be half the battle in light of the question.
Okay, I'm very conscious of time. I think we've answered most questions, but not all questions. I would suggest we draw the meeting to a close, but if people haven't had their questions answered, then do feel free to get in touch with us after this, and we will see if we can give some answers to you. Like I say, the recording will be circulated. I expect the early part of next week, along with the presentation slides. A couple of housekeeping points. We have some forthcoming In-House in Focus webinars. The first is on Wednesday, the 10th of March, and that is around insurance and hints and tips around managing insurance claims effectively. And then on the 24th of March, we're going to look at some boilerplate clauses and talk about why they shouldn't be just viewed as boilerplate and actually merit some proper attention. So look out for those invitations. Feedback, please can you give us some feedback? Like I said at the start, your feedback is very valuable to us in helping us shape future events. So it should only take a couple of moments, but we would really appreciate it if you could complete the survey. And I think that is all from us today. Thank you for joining, and thank you, Neil and Morgan, for that very informative presentation and dealing with as many questions as you could.
Thanks, Jane. And as set out on the slide, if anyone has any questions they particularly want to address to us, then you've got our contact details there, and we will try and answer them after the event. But thank you, everyone, for your time.
Okay. Thank you.
Thanks so much, guys.
Have a good
Thank you.
day.
Goodbye.
Bye.